he is, but we're going to see if it's
Streaming live on Facebook.
Is that what it says?
That's what it says.
Okay.
Looks like we're on.
Good. Okay. So we are here today with Keith Dunnigan and Laura Ferret of BPE Law. And so we're on my personal page because the other one wasn't working, but I know I have a lot of people who are on both. But we're excited today to be here with them and just ask questions that we know a lot of people who own investment properties right now are wondering. And there's a lot of changes that have happened since COVID with tenant rights and also landlord rights. And we know even since we last talked with Keith on the same platform, in I think October or November of last year, there's been even other changes. Things have been extended. So the biggest questions that we get asked as real estate agents are often, well, I have an investment property, there's a tenant in there, and I want to sell it and take advantage of this great seller's market that we're in. So tell me a little bit about how they can go about that, but also some of the pitfalls around, trying to sell a property right now while a tenant is still occupying it.
Wow, that's about as open-ended of a question as you can ask a lawyer. How do we have 3 hours for this one or 4? No. No, I don't have 3 hours or 4. There are so many things going on. It's craziness. I have Laura Ferret, who's an attorney with our office, sitting here because she's way smarter than I am. I'm the beauty, she's the brains, right?
Vice versa.
Am I supposed to say stuff like that? I don't know. We got to have a little bit of fun in all the craziness that's going on. No, but I'm gonna let Laura talk a little bit about, there's so many things going on. There's a seller's market. We see this all the time, but there are definitely pitfalls and you want to navigate appropriately, because if you don't navigate appropriately, you end up with losing your eviction lawsuit, which then with retaliation claims and things of that nature could keep you out of the unlawful detainer form for up to 6 months. So I'm going to let Laura take a shot at answering the technical component of that question.
So I'll just start by saying, always make sure to check where the property is located to see if there's any local ordinance that applies that could possibly be more restrictive than what the state has going on. For example, depending on where the property is, Sacramento City does have its own law that actually is a little bit more strict than the state law. So just always check, this comes with that caveat that check the local jurisdiction. But, a lot of people know that in 2019, California passed a just cause eviction law. That law generally only applies to, multifamily residences, apartments, duplexes, things like that. But what the state has done during this pandemic is apply those just cause eviction laws to everybody, whether or not that property would normally be subject to the just cause eviction. It is right now. Through June, the end of June 29th, currently, unless it gets extended, you cannot evict for any reason like you normally could have. You can only evict for certain reasons that are listed under the law. So, a lot of people are hurting on both sides, but we've been very busy because a lot of property owners are really suffering right now with properties where the tenants can't pay or are destroying the property and they're feeling stuck. But there are ways out, and one of the best ones available is to sell the property. So I think one of the questions you asked is, can you just give the tenant a 60-day notice that says your tenancy is being terminated because we want to sell? Usually that would be okay. But right now, under the COVID moratorium, it is not. What you have to do, what we recommend doing, is giving the tenant a 120-day notice of the intent to sell the property. And what that does is it gives the owners the right to go in with any actual or prospective buyers, agents, inspectors, things like that, upon a 24-hour notice. So that's your first step, is to give that 120-day notice, get the property listed. Once the property is actually sold and is in escrow, then you can give the tenant a 30-day notice to terminate their tenancy.
Okay.
Now, one of the things we want to think about, is there any restriction on giving that 30-day notice? Say, let's say you've got an investor, they've got this house, they want to take advantage of it, but they know that they're selling to another investor.
Yeah.
Are there going to be any limits to the ability to use that eviction basis in that scenario?
Yeah, Keith brings up a good point. That is a important limitation on the right to use this exception to evict a tenant during the COVID moratorium, is the buyer has to have the intent of actually occupying the property. So you can't be selling to another investor, someone who wants to flip, someone who wants to continue renting. The buyer has to intend to occupy the property for at least 1 year.
And then if that's like a duplex, do they have to occupy one unit? I want to say.
Right.
Two. Okay.
Yeah.
That's interesting. Okay. So then, because we do have like one of our other clients that they did give the notice and then the tenants moved. So, but I guess it's hard if the tenant doesn't know that you can't give notice, but technically, if you're looking at the law, you are not supposed to give notice right now if you want to sell, except the 120-day notice, which then
Correct.
You can list it after the 120 days are up, or no, it says for 120 days, I can do what, try to sell the property and all that.
Yeah. And one of the things to think about is once you've given that 120-day notice, you give the 24-hour notice to show the property, make sure, the code is super finicky on this. So technically, if you look at the way the code's written, it's during normal business hours, which tends to be like 8 a.m. to 5 p.m., maybe 6 p.m. But here's the problem, that 8 a.m. to 6 p.m., that's Monday through Friday.
That's hard.
Think about the impacts to the person who wants to sell and they want to have an open house on Saturday, because, well, like some counties still don't even allow open houses. Not that very many people are following that rule, but you got to think about that. Most people, when they're going to do the open house, they want to do that on a Saturday or a Sunday because that's what's going to create the foot traffic. Mm-hmm. Under the statute, the way it's written, it's during normal business hours, which is during the week. A lot of tenants won't fight you on that, but some will. And if somebody's going to fight you on that, get your attorney involved and think about how do we incentivize the tenant to cooperate.
And that's the other question too, is what are some ways? Because with that, it's like 120 days, the tenants are in there. We know on the real estate side, you don't get the most money for the house when the tenants are typically in this market, because they're not going to keep it up as well. They're not going to be as flexible when you want 15 showings in a day. So how can people, incentivize the tenant and then to leave? So let's say somebody says, okay, I have this investment property, I want to sell it. Can I go to the owner and say, hey, my intention is to sell this property in the next, 2 months. If I pay you $3,000, would you be willing to relocate out of the house today? Is that legal to do that? And how would somebody do that? Work-wise?
Yeah, that's definitely an option. And another important distinction I want to make is that there's the question of what type of notice can you give the tenant to terminate their tenancy, and the separate and distinct question of what type of notice will hold up in court if the tenant won't leave voluntarily and you have to evict. So it's not necessarily wrong for a landlord to give a tenant a 60-day notice saying, please leave in 60 days. We intend to sell the property. The issue becomes if the tenant doesn't leave before that 60 days up, you could not go into court and evict on that notice during this COVID eviction moratorium. So, in situations where the landlord thinks the tenant will be cooperative, they can give it a try. But really the only notice that is going to allow you to evict the tenant that holds over based on a sale of the property is that notice saying you're already in escrow. It's a 30-day notice that you're already in escrow.
Okay. With that, can we switch to, did you hear the story about the family in Southern California who purchased a property? And this was pre-COVID that they closed, but the seller for 12 to 14 months is still there. How is it? Is it just our state? There's all these political, people going back and forth that it's this political thing. Is it can they really not do anything about that situation if you're familiar with it? Like they've taken over, they said, turn off the utilities. They said we did, he just turned them back on. Like, is that true that there's not much you can do because of this in that situation?
Are you familiar with that case? Because I am.
No, yeah.
Okay, I'm familiar with that case down in Southern California. And a lot of the problems with that, it's not predicated on state law, it's predicated on local ordinances. And as Laura hit on at the very beginning of this, she talked about the fact that these local municipalities, they may have stricter requirements or stricter moratoriums than what the state has. Right here in Sacramento County, Sacramento City proper has a much stricter mechanism dealing with evictions than Sacramento County or Folsom or some of the other municipalities. And so in that situation, you have almost a blanket prohibition of eviction during COVID. So anybody can sit here and say, I have this COVID issue in this municipality, and they're prohibited from terminating or evicting them. When you look at the state law carved out as a just cause, a holdover seller. That is an absolute reason under the statute to evict somebody. But with these local jurisdictions, these local ordinances, it's preventing it. And the problem that comes up in that situation is many of these people, they go in, maybe they get an FHA loan, maybe they get an owner occupied loan, they get some sort of VA loan. All of these loans have requirements that within 60 days, they have to take possession of the property or their loan can fall into default. So that's a problem. I had one of those cases. It was in April of last year. The closing date was like April 7th. So we're 2 weeks into COVID. Seller goes and gets a doctor's note on April 5th, 2 days before close. It says they can't move. They're a vulnerable individual, but they don't tell the buyer. Buyer gets a VA loan, which requires them to take possession within 60 days. Buyer's already given notice. They're planning to move in. They're vacating their apartment. They close with the anticipation that on April 7th or April 8th, they're going to get the keys and they're going to move into their new home. Closes and seller says, no, I'm not leaving, creates all these documents. And I mean, at the point we had the text messages and some of the emails between the seller and their doctor that showed that they were putting this together. And we accused them of fraud. And eventually it worked out for this person and that person left and our client got into their home. But a fraud case takes years and years and years to work their way through the system. So what a lot of buyers need to be thinking about is if you've got this seller, and the first thing that should trigger it is if a seller asks for a SIP, and for your clients out there that don't know what the SIP is, that's a seller that remains in possession. If they're asking for that SIP, put a big fat penalty on it. Make the seller hold back $20,000, $25,000, $30,000 that's going to get forfeited if they don't leave. Because the fastest way to get them out is to hit them in their wallet. That's the fastest way to get them out. But then be cognizant and hope that if you find yourself in the situation, you're not in one of those municipalities that has carved out blanket moratoriums on sellers remaining in possession and the eviction related there too. So that's been the big one. That locality just had a really strict moratorium in place.
Got it. And what's hard right now, because the market is such a seller's market, like on our side for buyers, it's like suggesting when there's gonna be 15 offers, like, oh, write in a $25,000 security deposit is almost like, going to blow our chances, but is it worth it to be in this situation like those clients in Southern California? If that would have changed or not, we don't know, but like it may not because of the way it is, but it's hard when you're like, oh my, it is so hard to get.
It's the risk right now. Think about this.
Yeah.
That Southern California home, if I remember right, that was like a $900,000 deal for a young family that bought that property. I mean, you're talking on a mortgage, that's $4,000 to $5,000 a month in rent.
Yeah.
Not rent. That's a $4,000 to $5,000 a month mortgage payment. And they don't have the benefit of living in their home, which means they're carrying the mortgage payment and they're carrying rent. That $25,000, if the seller said no to the offer, that just saved you a year's worth of mortgage payments.
Totally. The risk there, I think right now with the way the market is, buyers are just getting desperate because they just want a
Yep.
house. There's like, everybody's fighting for it. So it's hard to, we can suggest it and it's hard to like say,
Yep.
it might hurt your chance, but I do try to explain to the listing agents,
Yep.
like, hey, due to some of these extreme cases, like that's the only reason. It'll be held in escrow, the buyer won't take it, but we just need some reassurance just in case, something happens.
We need to make sure the seller gets out.
Yeah. Yeah. It's crazy times. Okay, so we talked about, just to clarify, if they want to try to give a 60-day, they can for these clients that want to sell. And then it's only if, and would you write in there, I guess, like seller is willing to compensate,
Don't stick it in the notice. Never, ever, ever stick it in the notice. That's a good way to take a bad case and make it worse.
Okay.
Yeah, if you got a client that's looking at doing something like that, do the cash for keys on the back end. So the best way to do that is to serve the notice, give the tenant 24 hours to process, and then have somebody reach out and say, hey, look, I represent so-and-so. I understand that there's a notice been given. My client understands the difficulty of all of this stuff. They'd love to work together with you. You've been a good tenant. My client's willing to provide cash for keys to incentivize you and help you cover some of the costs of relocation. We're not going to cover them all. We can't pay for everything, but we're going to help you bear some of that burden. And the best way to do that is recognize you've got this finite period of time that you've got to deal with the tenancy and the transition. Stagger it. Give a tenant 3 options. If you're out of there in 60 days, we're going to pay you X. If you're out of there in 45 days, we're going to pay you Y. Make sure it's a little bit more. If you're out of there in 30 days, we're going to pay you Z. If you're out of there in 15 days, we'll give you a whole bunch of money. Just get out, because because you got to be thinking about, you want to incentivize.
Right.
And right now, it's not only is it a seller's market, it's a landlord's market. People may have been in this property for 6-7 years and they may be paying 15 or 20% below market.
Right.
And they're going to move out of that property and they're going to be paying 100. They're probably going to be paying a premium because some of these localities are just so expensive. I mean, I've been looking around. I'm not in the market, but I'm always curious to see what's going on. And you look at, like in Folsom, some of those new apartment buildings are going up. They're like, what are they? 2-bedroom, 1-bath, and they start at $2,100 a month.
Yeah.
And so you're watching this stuff, and you have to balance cash for keys. This is not cash for keys like it was in 2008 when the value was depressed, and you could pay somebody $1,500 or $2,000, and they could turn that money into another month's rent somewhere else or a little bit more. You've got to be thinking about these numbers because of the market are going to be a little bit bigger. And it's just because that's the way the economics of housing is working out right now.
Yeah. So would you suggest, like, if it's Z, the highest payment, you might pay somebody who is paying $1,500 a month, like $4,000?
4, 5, 6.
Yeah.
I mean, think about this. If you can pay somebody $4,000, $5,000, $6,000 and you bought this house 20 years ago, or maybe you bought it 12 years ago in 2009 when the market's just cratered, and you buy that house for $150,000, and now you're getting ready to flip it for at $450 or $500, $6,000 is a good investment to get that done.
Absolutely.
One thing I can't stress enough: if you're going to do cash for keys, get a good cash for keys agreement. It is worth every penny to be able to walk into court with an agreement that says the parties have agreed to terminate that lease and to enforce that termination.
Interesting. Where do they get that at? Can you guys provide that?
www.bpelaw.com.
Okay, perfect.
I know, we'd be happy to help.
Perfect. And I know, like, the ones I remember, I used to work for a foreclosure team. I think it was like a Word document, like 3 sentences they signed. I mean, I don't remember for sure.
Yeah.
I'm sure to go back in my notes. It was very, like, I just remember being at some of those appointments, and I didn't seem that like legal.
They're a little bit more complex these days because of
sure.
rental. What's the word I'm looking for?
Rent control. No.
Rent control. That's the one I'm looking for, because of the rent control laws. So they're a little bit more complex, and making sure there's special verbiage related to I am giving you money, and in exchange of me giving you money, you are going to vacate and you have terminated this lease. And the main thing is to make sure that termination occurs on the signing of the agreement and not on the day that they vacate. The mistake that a lot of people make is they go, okay, I'm going to give you this cash for keys. I'm going to sign this agreement, and it will be deemed terminated on the day that you vacate the property. The problem is they didn't vacate the property. Now you're trying to enforce it. And the court looks at it and goes, well, it doesn't terminate until the day that you vacate.
Yeah.
So making sure that you have the right language that says, upon execution of this agreement and the exchange of some consideration, this lease is now terminated at that point.
Yeah. Yeah. Good. All really good points. Did you have something else to add?
Yeah, so I was just going to say the ideal case for a cash for keys situation is one where you do have a valid 60-day notice to terminate tenancy that falls under one of those exceptions for the COVID moratorium. So you tell the tenant, you know, basically the 60-day notice, you're going to have to leave anyways at the end of the road. If we have to go to court, we will win. So you can either go the hard way or you can take this money to leave now. So in kind of determining how much money to offer the tenant, that's something that you weigh. Do you have a valid 60-day notice, and are you just weighing the cost of trial versus, you know, getting the tenant out earlier, or do you not really have a valid reason to evict at all right now? That's where you might be wanting to offer more money. But generally, we do advise our clients to think about kind of the cost of, to start with like a month's rent and deposit to get them, you know, somewhere else.
Yeah.
Yeah.
Okay. All really good info to know. Okay, I have a couple more questions. We talked about that. And then what recourse, let's say the tenants don't move, well, and then you said like if it's during COVID and you give us a they don't move, is there any recourse for landlords? Let's say the tenant's been there 6 months, they haven't paid because of COVID, then maybe the owner would like to sell but can't. Like, what recourse do landlords have in those situations? And do you see that June 29th date possibly being extended?
So if an owner gave a valid 30-day notice saying that the property's in escrow, it's a 30-day notice to terminate and you have to leave within 30 days, and that tenant holds over, the recourse is that the owner goes into court, an unlawful detainer court, and asks for the eviction and asks for the holdover costs from the date that 30-day notice expired to the date that the court actually orders them, you know, to leave. But that process, what it looks like is you file a complaint with the court, you serve it on the tenant has 5 days to answer. Depending on whether or not they answer, the easy way is if they don't answer at all and you can take their default. Once you have that default judgment, you can get what's called a writ of possession, where the sheriff actually goes over there, gives them a notice that they have 5 days to leave. At the end of that 5 days, if they're still there, the sheriff will physically remove them and change the locks on the property. But if an owner gives a notice to terminate tenancy that's not actually proper in the eviction moratorium and the tenant doesn't leave, then there's really no recourse at all at that point. They just have to reserve a valid notice, find an exception that fits their situation, and kind of start over.
Which includes like heavily remodeling the property. There's like a number of them, right? Of what
there's a number of exceptions.
Unfortunately, the heavily remodeling the property is one exception that's allowed under the just regular just cause eviction law that is not allowed under the COVID moratorium.
Oh, interesting. So what would be one of the more common reasons for being able to use the just cause during COVID?
Yeah.
So if the tenant's creating waste of any kind, if they're kind of, wrecking the outside of the property, causing a nuisance, if they've violated the lease in any way, if they've brought in other people without the landlord's permission, they're subleasing, and the best situations are where the tenant's, breaking some rule. That's going to be the strongest case for the owners to get them out. Otherwise, the owner wanting to move into the property on their own, that's a pretty common one.
But the owner needs to actually move into the property. They can't
Yeah.
just say, I want to move into the property. They
Okay.
need to actually move into the property.
Okay.
So,
What if they aren't, let's say that they're not intending to sell it, but a tenant is just behind because of COVID or just because then they can't catch up, then what, are there any protections for landlords in that situation right now that they can do anything with that?
Well, it's actually one of the strongest pieces of this eviction moratorium is that you cannot evict any tenant based on the non-payment of rent if the tenant fills out a declaration saying that they've been affected by COVID. So what I really advise is a general tip and trick, even if the tenant's not paying and they know that's why, you still got to paper the situation, jump through the hoop, and make the tenant jump through the hoop as well to sign that declaration every single month saying I can't pay this month because of COVID. And that way they do have the paper trail for that. If it comes out later that the tenant was dishonest and just kind of trying to game the system, that owner will have, that paperwork where the tenant signed under penalty of perjury every single month that they were affected by COVID. The other thing that's recently become available is owners who have tenants that aren't paying, that where the relationship hasn't soured too much and the owner's okay with the idea of letting them stay past this eviction moratorium, is that the owners can apply for rental assistance through the government.
Got it. Okay. And is that just a percentage of the rent?
It's up to 80, it's up to 80%, but the thing that the investors got to remember, it's not a first come, first serve model. We had a lot of grants and money that was floating around last year that ran out really quick because it was first come, first serve. But under the state rental assistance program, it's really targeting certain communities as the priority. And I don't remember the numerics on it, but I want to say it's, people below, communities that are below the average medium wage, something like that, median income, they are the first priority. And then there's this hierarchy.
Got it. Okay.
So just to recap, if an owner has a tenant that's not paying, the process is that the owner would serve the tenant with a 15-day notice to pay rent or quit. That notice has to come included with that declaration for the tenant to sign. If the tenant signs and returns that declaration within the 15-day period, the owner cannot evict the tenant for that reason. But if the tenant does not sign that declaration, the owners are in most cases good to go through the eviction process.
Is the eviction court, or are they still taking quite a bit of time for the evictions right now? Is
Yes.
it backed up still?
Yes.
It'll be backed up for a little while.
Mm-hmm.
Okay. How long does it usually take? Or is there a time?
Right now, there's no such thing as usually,
Okay.
right now, we've had some cases that run 60, 90 days
Mhm.
rather than the normal, 30 days and done.
Got it.
There's no such thing as normal right now. It's kind of roll the dice, see how fast you can get this done, and just cross your fingers and hope that you get in front of a judge fairly quickly.
Mhm.
But there's just so much backlog. You're talking about the UD courts were closed from basically March 19th until almost the end of last year.
Yeah.
They just weren't doing, they were doing some here and there, nuisance cases, things like that. But for the most part, it was not business as usual. And so you have all of that backlog, all of those cases from January and February and early March that are pre-COVID that have just lingered for a year. They've got to get cleared out. You've got all the COVID cases that have gone from middle of March all the way to December. They are still in the queue. And now you have all the new cases. Realistically, it's going to take, once we get back to processing at full speed, it's going to take a good 6 months to catch up.
Caught up. Makes sense. Well, this has been super helpful. Thank you guys so much. It's just great to hear, because we have clients asking us, and of course we always encourage them to go, for you guys usually do a flat fee consultation initially
Yeah.
for clients, and it's totally worth it when you're all these like really
Yeah.
detailed, in-depth questions, especially as the laws are changing. It's so important that people
Yeah.
get legal advice. So where can they find you, and tell me a little bit about, you know, your cost for that consultation and how that all works.
So the best way to find us is go on to the web, BPE Law, www.bpelaw.com. We're on the web. We've got a ton of resources on there. The number, if you want to schedule a consult, 916-966-2260. Our receptionist is very friendly and she would be happy to help get a consult scheduled with Laura. Laura is fantastic. She knows this stuff inside and out. Don't ask for me because I'll make it up. I know just enough on the landlord tenant to be really, really dangerous. And I also know just enough to know that I need to walk down the hall and talk to Laura because she's got this stuff figured out. That's the best way. We offer still that flat fee consult, $300 for 1 hour. And really the design is to help landlords navigate this ever-changing complex system. And the one thing, you know, we've worked with a lot of landlords over the years where they got so accustomed to just going out and they go, I've got my bank of forms, I'm going to do my notice, I'm going to send it out. That bank of forms, that bank of notices that you've been using for the last 20 years is probably not good anymore. And it's probably going to create more headaches. So right now, especially as these laws are changing almost monthly, you know, I know you hate it. You don't want to hear about the added expense, but do it right. Do it right and do it once. That's the best advice I can give. Laura?
Yeah, I agree. If you're using those car forms, check the date at the corner because they've all changed. And yeah, give us a call. A lot of times, you know, we can give the owner a good course of action just in the consult. Other times it takes a little bit more care. But we're here to help.
Perfect. Well, thank you guys so much for being here. And we'll get this uploaded to YouTube and we'll be sharing it out. And we just really appreciate all the info, and we'll be talking to you soon.
Thank you.
Thank you, Jenica. It's always nice to see you.
Nice to meet you. Take care. Thank you. Thank you.
Bye.
Okay, bye.